Creating a last will and testament in Georgia, in many cases, isn't only accomplished by seeking legal advice from an expensive lawyer. In fact, wills that include all of the appropriate estate planning instructions can be made by oneself if provided the right guidance. In this video, we'll discuss the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Georgia, and how and where to create an official will. Let's begin by looking at wills and their importance. A last will and testament, also simply known as will, is a document used to communicate in writing how an individual wishes to distribute their property among family, friends, and other beneficiaries after their death. It's recommended that all adults have a will in place, especially those in the later stages of life. But what occurs if no will is left in Georgia? A person who passes away without a will loses full control of who inherits their property. The state of Georgia and its probate laws will dictate how the deceased property is handled. The assets are typically passed to the deceased spouse and/or any children. Since clear instructions aren't left, disputes can inevitably arise between loved ones regarding who is the rightful heir to certain property, which may lead to drawn-out court trials. One can avoid any confusion by making a clear will document, and often without an expensive attorney required. A person of sound mind can draft his or her will in Georgia with the following essential information: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's review some legal requirements in Georgia. Last will and testaments in Georgia must be signed by the person to whom the will belongs, known as the testator, in the presence of 2 or more trusted, competent witnesses. Though optional, it is recommended that the witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once created and signed, the document will be legally binding. Multiple copies can be made and given to the executor of the will and any other trusted individual for safekeeping. We're eForms, the biggest database of legal documents. We've created state-specific last will and testament templates for Georgia that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions. Click on the link below to begin creating your will now. And don't forget to like and subscribe for more daily videos.